We just to give we'll just take it down. Because
Go for 5 minutes.
Yes, certainly.
40 entries in the state list. And out of the 40 entries, 13 entries are subject to list 1 or list 3. So virtually, out of 168 legislative entries throughout, general entries, I'm not including tax. Out of 168 general entries, there are only 40 in the state list. And out of 40, 13 are subject to either list 1 or list 3. So only 27 are left to the states.
So my humble submission is, entry 8 should be interpreted to preserve the state's legislative competence
In its widest amplitude.
But when the attorney,
When the solicitor, I was just thinking to myself, just a thought came to my mind.
According to you, admittedly, even according to your position, would be outside the field of entry 8.
Outside entry 8, once, not only according to me, according to parliaments after the amendment, once the liquor is removed from my factory, then it comes under parliamentary control. Once it is purchased by the paint factory for making a paint or purchased by a perfume company or by somebody else, I have no control over it. UP government has no control over it. But I'm just giving, suppose for example, I decide, so as a legislative policy, I want to maximize my revenue. I'll say we are not allowing denaturing. Everything should be cleared for IMFL. I can do that. Take Bihar, they'll say no clearing for IMFL, only for industrial purpose because there's prohibition. So right up to denaturing is the state subject. And let us not dilute that is my humble request. I'll come to the next point on Tikaramji. I just wanted to say that in the Para 32 of the circular, basically Tikaramji UP Sugarcane Act was to be ultra virus, IDR Act and Essential Commodities Act. In Para 32, they say even assuming, if your lordship sees my submission, written submission, which I
You
give,
made the point, even assuming.
yes, even assuming, I'm saying it is not obiter. It is Article 141. What Justice Bhagwati is saying is, even assuming 18G is there, unless there is a notified order, the state's power is not taken away. It is not obiter. It is the ratio decidendi. Obiter is something which doesn't fall for consideration. And just it's a passing observation. Now, further, Tikaramji has been accepted to be correct law in Belson, 5 judges, and 3 other cases. That's in my written submission. I've given those 4 cases. So, Tikaramji's observation that unless there's a notified order, 18G doesn't operate is Article 141, good law, not obiter. Now, just see the Industrial Disputes Act in the IDR Act for a minute, and I just close my submissions. But in my written submissions, if your lordship takes my written submissions.
Mr. Datta, in case you require 5 or 10 minutes more, please don't feel rushed.
Other friends also. I'll take 5 minutes and I'll give to them because
Since we are concluding, or if you want to come tomorrow at about 3 o'clock, we can wrap up.
we'll take 5-10 minutes more. But what I can suggest, lordship, tomorrow at 3 o'clock, the others can reply.
Not there tomorrow. So let's conclude today. We'll conclude today. We'll go a little longer also.
I'm so grateful.
We'll go a little longer, but all of you don't feel rushed for time. We'll go a little longer. No difficulty.
If lordship wants to take a break and come back also, we'll wait.
We'll do that. Just use the comfort break and come back.
Yeah.
There's an Eid celebration by the bar, but the bar can wait for another 10 minutes.
Yes.
So that's all right.
They definitely know I'll call them a lot. Eid celebration. Yes. So, my lord, now what I did was I analyzed this Industrial Development Regulation Act. Now the argument was that 18G per se creates an occupied field. If your lordship now sees my written submission 1O, very interesting. Of all the sections, every section except one section, every section says central government by notified order, by instruction, by notification in official gazette, by rules. Section 20 is the only section which says that on management and control, state law will not operate. Section 20 is the only which your Lordship mentioned last time. Once Section 20 says that management and control is by IDR Act, all state laws get repugnant. But every other provision, your Lordship just see my written submissions. At page 1, it's now 1O. Just take it. Please come to, I made an analysis. Question, but what I've done is I've answered the questions individually. And Lordship will just come to question 3, 18G. Now, may I request your Lordship to see 18G for a minute, bro? 18G, if your Lordship can see the bare act. We all have read 18G1, nobody has read 18G2. What was 18G1? 18G1. What you have seen number of times, I won't read it again, by notified order. Please see 18G2. Without prejudice to the generality of the powers conferred by subsection 1, a notified order may provide for A to H. Now, my humble submission is, today there is no notified order at all. So our submission is the whole field is open to states. Tomorrow, my lord, hypothetically, the notified order may cover only A, D, F.
Right.
My submission then is, whatever is not covered will be open to the state legislature. Because the notified order has got a scope of covering a territory of A to H. If Parliament chooses to cover only A, B, C and doesn't touch the others, technically nothing wrong.
Except that 18(1) expressly confers the power on the central government.
Exactly.
Now, where do the states get their power?
No, if the central government doesn't confer it, because entry 18G is...
That's a little far-fetched.
No, I'll tell you what. I'll tell you
The
what.
central government, before it decides whether to exercise or not exercise the power,
Yes.
has to be satisfied about the conditions precedent which are spelled out in subsection 1. If the central government comes to the conclusion that the conditions precedent are not satisfied and therefore does not exercise the power, the state can't say that, well, I'm taking a different view of the conditions precedent and I'm exercising the power
I don't
because the central government has not exercised.
Your Lordship is right. I will not make such an argument. What I wanted to see, what Tikaramji said.
That's right.
Only to the
Says that the states can exercise power only under NT 33 of list 3.
Exactly.
Because in respect of a controlled industry,
Exactly.
except for the fact that to the extent to which the field under NT 33 is covered by the IDRA,
Yes.
because now we are very clear that 18G is an exercise of the legislative domain under NT 33.
33. Same language.
Right.
Yes.
Therefore, once 18G has occupied the field, then the states cannot say that I will bring about other legislation or exercise power under 18G because the central government is not exercised.
No, I don't say that. 18 is a central act. There is no question of
Obviously.
exercising powers in the state.
So state, you are saying that the state can then enact a law,
No, I'm saying that entry 33 is concurrent list.
right?
So trade, commerce, production, supply, distribution is both parliament and state.
Right.
Entry G, 18G, the power to prescribe except production, they don't touch production. All other things, the state can make a notified order. The argument of the union is, once 18G is there, that is enough. According to me, because Lordship will kindly see, when Parliament makes a law, it can either make a law fully, which is fully operational per se, like the Income Tax Act or something like GST, it is fully operational, nothing is required. It can make a law which has to be implemented through a notification, through a notified order, subject to rules. So in that case, the law is still not there. The law, only the power is there, but it's not exercised. I am putting for the...
But except for the fact, conceptually,
Yes.
a failure, or let me not use the word failure, the absence of a notified order by the central government may be an indicator that the central government as a delegate of parliament does not consider it expedient to regulate that particular aspect.
Yes. In fact, I was going to tell you...
At this stage.
Yeah. No, in fact, Lordship will
In
kindly...
which case can the state say that, well, because this falls in a concurrent list subject, though Parliament's delegate has come to the conclusion that it is not expedient to regulate for a variety of reasons, the state will still regulate. That may be a little far-fetched.
No, what I'm submitting is entry 33 must be read in entry 26 and 27. supply distribution is open to the state legislature, subject to entry 33. What happens is once a notified order comes, it becomes an occupied field in entry 33 and it's a no-go zone for the
But if
states.
you, until the stage of a notified order, there is no occupied field.
There is no occupied field.
The doctrine of occupied field is not dependent on the administrative exercise of power.
No, I'm only
It is
submitting,
postulated on the existence of a legislative instrument.
I'm submitting, my lord, the doctrine of occupied field should not be mixed up with the doctrine of occupiable field. Occupied field means Parliament has occupied that field.
It has occupied the field by legislating, not
Sorry.
by providing for an administrative order under the.
No, I'm just leaving lots of interpretation.
That conceptually, it makes very difficult.
No, please see conceptually. Please see conceptually. Entry section 20, they clear bar of the states. Now there are many cases, management takeover, etc. is there. Many things of regulation, other provisions are there. We are only concerned with 18G.
Yes.
Only 18G. I am submitting the entry 33 will prevail over the state's power under entry 25 or 26 of list 2. Lordship will just take entry 25 of list 2, which is subject to entry 33. State list.
26, yeah, 26, 27.
Yeah, 26, 27. So trade commerce within the state, production supply within, of course, within the state will be subject to entry 33. So I'm only submitting that if entry 33 has not been exercised by Parliament by issuing a notified order under 18G, my powers under entry 26 and 27 are there.
So long as a notified order is not issued.
Not there, because what I'm submitting is in a law made by Parliament must necessarily mean a law made by, how does a Parliament make a law? It may make a law per se, or it may make a law which is implemented through a notification. If the notification is not there, no. In taxing laws, we say a lot, if the computation provision is not there, there is no charging provision. So if there is no prescribed rate, there is no duty. So I am only submitting your lordship, entry 18G, that's why Tikaramji, I use the word occupiable field.
Mr. Datta, is it your contention that today, because there is no notification,
Ah.
state can legislate on subjects touching 18G? Can there be a state legislation dealing with the aspects covered by 18G today?
Yes, my submission is take for example milk products. Take entry
Today
27.
there could be a state legislation touching the aspects covered by 18G.
Yes, scheduled industry it can be. So please take the scheduled industry, my lord.
So what you are effectively arguing is this, that if there is no notification under section 18G, the subject falls under 26 and 27 of the.
I'm not saying, no, that will be a wrong argument. I'm not making that argument.